Welcome to Your Inheritance, your rights, your obligations, your responsibilities, with your host, Peter Bochnewich. In each episode, you'll learn insights from experts. If you're being sued over an estate or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Now here's the host of Your Inheritance, Peter Bochnewich.
Good morning and welcome to the podcast. Today is Cesar Chavez Day here in California. We celebrate that day. It's a court holiday. Nothing we're discussing here today is legal advice to anyone, and anything that you view should not be considered legal advice. If you have a matter that is of concern to you, litigation, you should seek the advice of an attorney for your particular matter. Today, I'd like to speak with you about a recent experience I had in bringing a successful trial motion for judgment, which led to the complete defense of a fairly spirited litigation against a client I was defending in a trust and estate litigation matter. The trust and estate matter was approximately a value of about $2 to $3 million. And I won't mention any names of the plaintiffs and the parties in the case, but the causes of action are those that are, commonly asserted in cases of this nature. There was a lack of capacity case, allegations that the person who made the trust in favor of my client didn't have the mental wherewithal to do so. There was an undue influence claim against my client. There was a cause of action for breach of fiduciary duty as trustee, embezzlement, fraud and deceit, a whole range of causes of action, 9 causes of action that were asserted in a fairly lengthy complaint/petition brought before the probate court and tried to a judge. In California, there is no right to a jury trial in most trust and estate litigation matters. You're typically trying the cases before the judge that's assigned to that particular matter. So the judge is the trier of fact. The judge is your jury, that singular person in the black robes up there behind the bench. They're the ones who are going to be deciding the fate of the case and whether or not there's enough evidence for one side to prevail over the other. And I thought it would be interesting to give some background on this so that folks could understand that people have to prove their cases on their own merits. And if they don't meet the elements of the causes of action in the case, in trial, you don't have to call a witness necessarily in your own case in chief if there's not enough evidence to support the cause of action alleged in the petitioner's case in chief. Specifically, California Code of Civil Procedure 631.8, which is the motion for judgment statute, states that after a party has completed his presentation of evidence in a trial by the court, in other words, a court trial, the other party, the defense, without waiving their right to put on their own case, to offer evidence in support of his defense or in rebuttal in the event of the motion is not granted, may move for judgment. And the process of that, in my recent experiences, case was over, petitioner arrested, petitioner indicated to the court that they were done putting on any documentary evidence, they were done calling any witnesses, percipient witnesses to trial to testify in support of the causes of action. They had put their expert witness on with respect to what they thought was pertinent for their expert to testify to, and they completely rested. At that point, I had the opportunity to say to the court, I believe I would like to make a motion for judgment, or what would often be called in a jury trial. This wasn't a jury trial, but there's another name for it, is a motion for non-suit. Basically saying they've put on their case, they've come to court, put on all their evidence. when we take stock of everything that's been put on before Your Honor, there is nothing there that meets the elements of any of the causes of action that they put before the court, thus indicating to the court, I don't need to go on for another 5 days putting on a defense of those causes of action. It's sufficient for me to move for judgment because they have not met the elements necessary to support any of their causes of action. So that was something that we did, and I'll give you just an example of what we were able to illustrate. There was a claim for undue influence against the person that we were defending. And our position was there was no undue influence in the procurement of the testamentary instrument, the trust amendments that were at issue in this case. There was no influence at all. There was no evidence that our client even knew about what was going on. And so the fact that she was a beneficiary of it was not the product of any doing by her, notwithstanding the umbrage that the petitioner felt over the fact that she was getting a substantial share of the estate that she felt she didn't deserve. That is not liking somebody else, not thinking that they don't deserve it is not a cause of action. If you want to prove that somebody got something by way of undue influence, you have to meet the elements of the cause of action for undue influence. The petitioner themselves defined the undue influence according to a Welfare and Institutions Code standard. That is California Welfare and Institutions Code section 15610.70, which provides that undue influence means excessive persuasion that causes another person to act or refrain from acting by overcoming that person's free will. So if they're at the end of their case and they have rested, there is no evidence before the court that the person who created the testamentary instrument was bamboozled or induced to do anything or forced or coerced. And everything that they did, all the testimony that's coming in is that, no, this person was pretty sharp, notwithstanding their advanced years, and they had full command of their faculties, and they were actually quite assertive about whatever they did, and no one could tell them what to do about anything. If that's the way the state of the evidence is, well, you're not going to win an undue influence case. The petitioner is not going to win that case. And you can, by this motion, applied to the court for a judgment by illustrating that none of the elements of the cause of action were met. We were able to do that over the course of 9 causes of action, applied to 9 causes of action for lack of capacity, for undue influence, for removal of the trustee, for financial elder abuse, for breach of fiduciary duty, for breach of trust by a co-trustee, for fraud and deceit, for alleged claim of conversion and alleged claim of embezzlement. These were all singular 9 claims asserted against a client, and all 9 were dismissed, at least at this point in time. There may be appeal, we don't know. Not commenting upon giving names or anything like that. We want to protect it's a matter of public record, but I think it's appropriate to maintain the integrity of the case by not speaking about it in specifics with party names and so forth, and just speak about it generally so that folks have an understanding that there is a process whereby a case can be dismissed in trial and also prior to trial by way of motion for summary judgment. That would be the subject of another podcast perhaps. But in trial, if you don't prove your case and you don't put on the elements of a proper case in your case in chief, you run the risk of having your case completely dismissed, and the other side doesn't have to call any witnesses in their case in chief. They can rely on everything they've done in your case in chief. So that was a recent experience that we had, and that's what I wanted to share with you today. And that's a fairly short period of time here today, but that's our video for today. And I hope you have a great day. I hope this was informative for you.
You've been tuning in to Your Inheritance, Your Rights, Your Obligations, Your Responsibilities with your host, Peter Bochnewich. If you're being sued over an estate or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Thank you for your positive feedback, comments, questions, and for sharing the show with others.